Hello, students. We are going to continue in our Bill of Rights notes, starting at Amendment number 4, which is search and seizure. The amendment protects Americans from unreasonable search and seizure. It protects a person's home, papers, person, and personal effects. A legal search and seizure is permitted if a judge has issued a warrant or written court order allowing a search to be conducted. A warrant is issued only if there is probable cause. This means an officer must show that it is probable or likely that the search will produce evidence of a crime. A search warrant must name the exact place to be searched and the exact things to be seized. In some cases, courts have ruled that searches can take place without a warrant. For example, police may search a person who has given permission to do so, or if a person is under arrest. Police may also search without a warrant in a life or death situation. However, evidence found during an unlawful search cannot be used in a trial. So we're going to go over here again, and we should have already written in the name of the amendment is search and seizure. So the meaning of this amendment is here at the beginning, and we are going to have our person's home, papers, person, and personal effects protected from search and seizure. This is our right to privacy. So how can something be searched legally? With a search warrant, and that warrant comes from a judge. It's a court order, which is actually number 4. That is our question, is what is a warrant? And it is a written court order that is allowing a search to be conducted. And so this is a document. It's a piece of paper. And how does one get a warrant? Well, first of all, not anybody can just get a warrant. A police officer is who would need to be getting that warrant. And in that warrant, they're going to have to show that there is probable cause, which means that they have to give an explanation of why they are conducting the search. In addition to that, they have to tell who they are going to be searching, who or whose property, exactly where they will be searching, and then exactly what they expect to find. So this is where it can get a little bit tricky here. First of all, if police officers show up at your door, like our image here on the left, and they ask if they can come in and search your home, you should respond in asking them if they have a search warrant to say that they have the right to do so. And if they say no, then you don't have to let them in. You can close the door. As you can see, that's what would have been happening here in this image, that the police officers came, asked if they could search. They do not have a warrant. You can clearly see there's no warrant there in their hands. And so the door is being clicked shut. No, we're not going to let you come in and search our home. So these same officers would have to go to a judge, to the court. So let's say that it's this officer right here, because we've got a male officer over here. So he's going to go to the court and ask for a search warrant. So the judge is going to say, I need some information. And the police officers are going to have to provide that information. And again, what they have to tell them is why they want the search warrant in the first place. Is there a probable cause? Is there a crime that has been committed? Who is it that they are going to be searching? Whose property is it that they're going to be searching? And in some cases, it could be the person themselves that they're searching. Exactly where they will search and exactly what they expect to find. So I'm going to give you a little bit more insight on what a search warrant looks like. This is a real search warrant that I am going to show you here that I found to give you some information. Now you're going to see some things that are blacked out on here, or it's called redacted. And it's been redacted because this is a case that had to do with a child, with a minor. And so to protect that minor's identity, and also to, protect the family of that person, that information is not shown as public information. But it's okay. We don't need to know who the victim is here. We just need to see what it's like to have a search warrant. So a search warrant has a lot of details in it. This is just one page of the search warrant, and there's actually numerous pages, and I'm only going to show you just a couple of those pages. So up here at the top, I have circled the police officer who is trying to obtain the search warrant from a judge. And so he has completed the search warrant, filled out all this information in which the judge needs to know. So the first part here is exactly where to be searched. So it cannot just say a general location. It has to be very clear on what is going to be searched or where is going to be searched. So this says any and all motor vehicles located on the property which may contain evidence to include a 2001 green Dodge Stratus VIN number, which is a vehicle identification number, with a Colorado temporary plate, and then it lists the plate number, located in the rear window, all of which is located in the unincorporated area of the county of Teller in the state of Colorado. So a couple things are general. It's somewhere in the county of Teller in the state of Colorado, but specifically they are looking for a 2001 green Dodge Stratus, and not just any green Dodge Stratus. So if they come around and find a 2001 green Dodge Stratus, they're going to then look at the VIN number, the vehicle identification number. And if it doesn't match this number that's listed here, they are not going to have the right to search it. It has to be the exact car. And then again, it also has a temporary license plate that's listed with the number there as well. So it has to have those things in order for them to search that particular car. The next part that I have boxed around is the probable cause. This is the why. Why are we searching for this car, and why are we going to search inside this car? So this one's kind of like a checklist. These are options for the police officer to choose. And so there are 3 things that are marked off here: that it is or has been used as a means of committing a criminal offense. It would be material evidence in a subsequent criminal prosecution. And it is person, property, or thing, the seizure of which is expressly required, authorized, or permitted by a statute in the state of Colorado. So these are things that are saying that there has been a crime that is committed, and we believe that there's evidence in this car to prove that crime and perhaps prove the guilt of the person who committed this crime. So then it goes on to the next, attachment A. And again, I'm only going to highlight a couple of things here, but you'll see this goes on for a few pages. And now you see those black marks. It is taking out the name of the child, because again, this has to do with a child. So up at the top, I boxed around again, just the place that is to be searched again. So it's including the information about that same car, the green Dodge Stratus. And then I circled again the name of the officer that is looking to search this property. And then down here below, I put a box around. Now they're going to give some more specific information about this case. And once again, you'll notice that this goes on, but I'm pulling out the big pieces here for you to see. So on February 23rd, 2011, the officer was contacted by a homicide detective who worked for the Colorado Springs Police Department in reference to a missing 6-year-old boy. And again, that's his name that's blacked out there. So the detective was asked to help the North Carolina Police Department in the location of this child. And so they said that they attempted to contact the grandparents who live in the Colorado Springs metro area. The detective was advised that the mother of this 6-year-old, and they do list the mother's name there, Vanaya, I think is how you perhaps pronounce that, and her date of birth. She left North Carolina with a group of Black Hebrew followers and on their way to Colorado. So the detective informed the police officer in the Colorado Police Department that that she had only left with 3 of her 4 children. So meaning that the 6-year-old was not seen with her when she left. And so this is going to be now the reason why they are investigating because they're trying to find this missing 6-year-old child. And then it continues on to list exactly what is to be seized. So they talk about the car again up at the top. And if they find this car and they search it, these are the things that they plan to take if they find them. So children's clothing that shows signs of blood or bodily fluid, any clothing or personal effects that may belong to the child, the mother, and then it lists another woman's name there. I'm not exactly sure who she is because I didn't read all the whole report there. Number 3, any indication of the mother, and then it lists out the names of the other people that she's traveling with. But not limited to handwritten documents, rental agreements for residences or vehicles, or lodging receipts, any weapons previously described, to include any and all 9mm handguns and any and all 22 caliber weapons, and then any suitcases which may contain potential DNA evidence. So again, that could be blood or other bodily fluids. It could be hair. It could be skin cells, the fingerprints. There's lots of stuff that could have DNA evidence in a suitcase. So they obviously believe that this child was physically harmed because they're looking for child's clothing, any signs of blood or bodily fluid. They are also looking for guns. Now, in this, they are very specific about the type of guns that they are looking for. So if they find this car and they search in the trunk and they find, or anywhere in the car, and they find let's say a rifle, they cannot seize that rifle because it is not listed in the search warrant. So it has to either be a 9mm handgun or a 22 caliber weapon. If those weapons are found, they can be seized. Anything else that's not listed in this search warrant cannot be seized. So let's say they found, a kilo of cocaine in that car. That cannot be seized because it is not listed here specifically in the search warrant. Seems like it might be kind of weird that they couldn't seize it because it's an illegal substance, but there are rules that have to be followed in order to make sure that people get a fair hearing or trial, which we're going to see coming up in amendment number 6. So that is a search warrant. That is a lot of stuff that goes into a search warrant. And again, it has to be very specific. Otherwise, these things cannot be used in court, which is going to be another question that we're going to answer here in a minute. So when we go to number 6, how can a search be done legally without a warrant? Because this is possible. There can be legal searches done without a warrant. And so that is going to be found here in this paragraph that I just highlighted. One of the ways that it can be done is if a person is under arrest. They can then legally be searched by police. Another way is if there is a life or death situation. So if there is immediate physical threat, they can do a search. Here's an example. If there was, let's say, a domestic dispute that you heard going on in the apartment next to yours, and it sounded like, bottles being broken or things being thrown across the room, somebody screaming, maybe even yelling, "Don't hurt me," something like that. And you called the police, and the police show up, and they go to the door, and maybe nobody even answers the door. If they hear any of those things happening, someone crying or asking for help or saying, "Don't hurt me," or again, any signs of a struggle at all, they can enter into that apartment without a search warrant. And then lastly, permission from the owner. And this is possible. Some people will give permission for a search to be conducted in some cases because, they know that they have nothing to hide. There is no evidence that's going to be found, and they'll allow a search. Now, if a person chooses not to allow a search because there's no warrant, that doesn't mean that they're admitting that they're guilty. It just means that they're exercising their rights, which is perfectly fine. There's no right or wrong way to go about having a legal search conducted if you are the person who is accused of something. If you want to say no, you need to have a search warrant, that's perfectly fine. And if you say, sure, you can go ahead and search, then that's fine too. So number 7, what happens if an unlawful search occurs? And that is the last sentence here that I mentioned already. It cannot be used in evidence against the suspect in court because we have these rules in place for a reason. We protect people. You have to prove somebody guilty. There is a phrase that says that everyone is innocent until proven guilty. So we presume that you did not commit this crime. It is the burden of the prosecution to come up with the evidence against you, because otherwise there's no proof. You have to prove it. Number 8, some examples of places that can be searched with a warrant. So this list is unending, really, but I'm going to give you a few here. Obvious ones: a house, a car, the garage, the yard, computer files, paper files, your workplace, a storage unit, phone records, your body. It could be if you have a motorhome or you have a boat, any sort of vehicle that you might own, or any sort of space that you might own that might have things stored in it. These are all things that can be asked for a warrant. However, one warrant doesn't fit all places. As mentioned before, it has to be exactly where they're going to search. So if they show up with a search warrant to my house and they also want to search my work, they have to have a separate search warrant in order to do that. And in some cases, the workplace is not your property unless you own your business. Then that may be different. But if they show up at your workplace and they speak to the owner or to the boss and ask if they can search your work area, they can give them permission. They don't actually need your permission because you're not the owner of that workplace. Okay, so next we move on to the Fifth Amendment. And the Fifth Amendment is rights of the accused. So you're going to go ahead and put in the title, rights of the accused. A person accused of a crime is entitled to due process of law or fair hearing or trial. The federal government must obtain an indictment or a formal accusation from a grand jury to prosecute anyone for a crime. A grand jury is a panel of 12 to 23 citizens who decide if the government has enough evidence to justify a trial. This procedure prevents the government from prosecuting with little or no evidence of guilt. So I'm going to stop there for right now because we have several questions to answer just based on that one paragraph. So the meaning of this amendment is that it is going to prevent prosecution with little or no evidence. So a person cannot be tried for a crime unless they are presented for something called an indictment. So sometimes people also look at that as being guaranteed a fair hearing or trial. But what we really mean is that it prevents prosecution with little or no evidence. So due process of law is a term here that means fair hearing or trial. And what that means is that you cannot be denied life, liberty, or property unless you get that fair hearing or trial. So we have to have evidence against a person in order to deny these things. And if they're found guilty, they can be denied. Your life can be denied because you could be sentenced to death, or you could be sentenced to life in prison, which essentially is taking away your life. Liberty is your freedom, right? So if you're put in prison, you lose your freedom. And then also you could lose your property. Now that's not necessarily a guarantee, but if you are put in prison, chances are that you are not going to be able to have enough funds to continue to hold that property, and you may lose it. So number 4, what is an indictment? We have this definition over here that an indictment is a formal accusation by a grand jury. So a grand jury is different than a regular jury in an actual trial. This is saying that we need to determine if there's enough evidence to actually have a trial. And that is what the jury does. The grand jury, does. They decide if there's enough evidence to go to trial. So this jury, like I said, looks different than a regular trial jury. and that this is made up of 12 to 23 citizens. A regular jury has just 12, so this can have more than that. In order to have this go to trial, they need a majority vote. And remember, a majority is one more than half. So if there's only 12 of them, then they need to have at least 7 of them say, yes, there's enough evidence for a trial. Now, my image that I have here below kind of is the process of this. So we've got a robber, right? A burglar who is running out of, let's just say, an electronics store with a TV in his hand. He is caught in the act of committing a crime. So the police are going to come and pick him up. And then, even though he's caught in the act, remember we talked about this, every person is going to get to have these indictments and fair trials. They have to, otherwise our whole system is going to fall apart. So the police are going to take him to the grand jury. This is our grand jury right here. Now the grand jury is going to listen to them present what the case is against this guy over here. And they're going to show, let's say, video footage, and they're going to have some eyewitnesses of this guy stealing this TV from the electronics store. That is going to give them enough evidence to keep him in prison until his trial, or at least to call for a trial. There is an option of people to not have to sit in prison while they wait for their trial, and we will talk about that in the 8th Amendment. So this is the first part of the 5th Amendment. We've got some other things here that we're going to answer about the 5th Amendment. And so I am going to read here the next paragraph. Double jeopardy is forbidden by this amendment. This means that a person cannot be tried twice for the same crime. However, if a court sets aside a conviction because of a legal error, the accused can be tried again. A person on trial cannot be forced to testify or give evidence against him or herself. So double jeopardy says that it's forbidden. And so that means that a person, cannot be tried twice for the same crime if they've been found innocent the first time. And so this is to really prevent people from being harassed by police or by legal teams and saying like, well, I just know this person is guilty, even though we couldn't prove it in court. We're going to keep on digging, and we're going to keep on trying to bring them back to court. And that is not something that's allowed. They have gone through the legal process. They had an indictment that showed some evidence against them, but in court, it couldn't be proven that they were guilty. And so they were let go. And then that means that it's over. They cannot continue to bring them back for that same crime. Now, if they committed another crime, and it could even be the same type of crime, maybe it was a robbery of some sort. The first time they were found not guilty, and then maybe they did it another time, then they can be brought back for that other crime. Even though it's the same type of crime, it's a different event. So they can be brought back for that. Number 7, an accused person cannot be forced to do what in court? And that was also in that paragraph here. They cannot be forced to testify or give evidence against themselves. So this is called self-incrimination. Now, I think you probably watch enough TV or movies about courts that when a person is going into a court and they sit on the stand, this is the judge up here, and they sit on the stand. Next to them is a little spot for a person, a witness, to sit at, or in some cases it could be a victim, or in some cases it could be the suspect. And they sit in that spot. They put one hand on a Bible, they raise their other hand, they say they swear to tell the truth, the whole truth, and nothing but the truth, so help me God. So if you are the person who is on trial, you do not have to testify. And you would probably make this decision based on the advice of your lawyer, your legal counsel, your attorney, whatever you want to call them. You're going to probably listen to what they have to say. If they think that you are going to be coming across in the wrong way, they may think that it's not a good idea for you to testify. Now, once again, this does not mean that you are guilty. You are not admitting to guilt if you refuse to testify. You are exercising your right to not self-incriminate, because lawyers are tricky sometimes and they can ask you questions and twist your words around to make it sound like something that didn't really happen. And so it's for the protection of the innocent. So again, this is saying that they cannot be forced to sit and testify if you are the accused person. Then we have the next or the final paragraph here. Finally, the government has eminent domain. Eminent domain says the government can seize private property for public use, but they must pay a fair price for it. So eminent domain, government can take private property for public use, but must pay a fair price for it. If this ends up going to court, the court is going to determine what a fair price is. So because it's in the Constitution is always going to win. Remember, it is the supreme law of the land. So my image down here below is showing Uncle Sam, who is a symbol of the United States, U.S., Uncle Sam, right? And he is approaching a homeowner with money to purchase the home. And in his thought bubble here, he is dreaming up of building a school in this location. So they're probably buying up numerous houses right there. And so he's going to go offer money to these homeowners so that they can build a school. It's going to be for public use. So the homeowners can't really say no. If they say no and it goes to court, then they're still going to end up having to give up their home, but the court will determine what the fair price is. So if the government, is not offering them a fair price, and that's the reason why they say no, then that makes sense that you would want to go to court if you think that it wasn't a fair price. But in some cases, it may have been a fair price and you just are unwilling to sell, and you're not going to be able to hold on to the property because of eminent domain being in the Constitution, and this is property that would be used for the public. Okay, so that ends the Fifth Amendment. So if you are needing to move on to Amendment 6, you are going to need to go to the next video lesson.